Hello, happy Monday. I am alternate juror. I hope you guys all had a great weekend, a great Mother's Day, if that is something that you do, uh, all that good stuff. I hope it's nice weather where you're at. And Carmen, I wish it would stop raining in Texas. Good morning, Gabby, and good morning, Stormy. I am so glad you're back. You are never, ever, ever, ever allowed to go on a cruise ever again. I guess maybe unless we all go with you, but I'm not sure how you're going to get Chrissy and I onto the ship. You left and everything just went nuts. Um, oh, we blamed everything on you that went wrong, just so you know, Stormy. So if you go back and watch any of the streams that you missed while you were gone and anything goes wrong, you get blamed just because you weren't here and things started falling apart when you left. Um, if you haven't heard, Stormy, Ty is back in jail. That happened while you were gone. Um, let's see. What else happened? Gabby, help me here. There was just a lot of weird stuff. Yeah, we were hoping you were enjoying some ice cream. Like a lot and lots of ice cream. Ty is in jail because it's really weird. He supposedly did not go do one of his urinalysis tests on time. It is very strange. They set his bond at $3.1 million. He is still in Oregon. They have not, well, as far as I know, they maybe got him over the weekend. But yeah, so that happened. I don't suspect that he will get out before his trial in September. Um, it was, yes, Gabby, that is like the perfect way to do it. It was just a bunch of days that was really weird and it just felt so upside down. Last week was, I haven't been on long enough to say it, so it was a crap show. It just really was. I mean, there was good things and bad things and then weird things and off things. So we just blamed you. I'm sorry. But I do hope you had a great time. I am glad you're back. Yes, Gabby was punching the air during the Adam Montgomery sentencing. Uh, and I just have this visual in my mind of Gabby punching the air. I hope she has her, hope you have your little outfit on that you sent a picture of. Yeah. Ah. So I saw. Yes, you did. Yes, Stormy. Gabby called while I was streaming because she wanted to say Boston Harbor, but she didn't think I was going to answer my phone. I said, why did you think I would not answer my phone? So I answered the phone because I thought she wanted to say Boston Harbor, and I just put it up to my mic and she's just swearing. I was like, didn't you want to say Boston Harbor? She's like, yeah, Boston Harbor, whatever. Get out of here. I can't do any of the accents. I give up. But yeah, it was funny. And oh my goodness, Friday, I ended the stream abruptly and I felt bad. Hello, Super Sun. Glad you're waving at us as you go back to work. Uh, I'll talk about that in a minute. I'm trying to give people a little bit more time to kind of trickle in here if they do. I don't know if Chrissy's out there or if she's been super busy. Yeah. So you leave, Stormy. Chrissy just decided to get super busy. Carmen decided that it needed to flood in Texas. What's up, Dill? You are in your final little countdown for baby. It's going to be soon. I can't really think of anything else right off the top of my head. If you just hear it in the stream, Stormy, you'll hear your name a lot in last week's streams. um, I do have a few things that hey, Alicia, I need to, how you doing? Good morning. That I need to, well, I have one thing I'm going to change after last Friday. I'm sorry that I abruptly ended the show and I kind of left it hanging. I didn't mean to. I got an email that caught me very off guard, and I needed to respond to it. I'm not going to go into any details. I'm not going to say which trial it was, but I was asked to remove a trial that we covered. It was only a 2-day trial. It's not like it was a major one. I understood why they wanted it taken down, so I did. But it got me thinking, and not everybody has the resources to, if they are charged with something and taken to trial, as this person was, to get their record cleared. I don't fault this person for having the resources, having the things that I think they probably have available to them to be able to get their record clear. Don't blame them at all. But everybody doesn't have that. So for me going forward, if it's not a major trial, because there are people that are found not guilty, like on court TV or law and crime or yeah, it's there, it's public. This was a smaller trial. I'll leave those up. But if I do a smaller trial like this one was, and that person is found not guilty, I will leave it up for a couple of days afterwards to make sure everybody can see it. And then I'm going to, I'll remove it, because it's not fair to those people that don't have the resources that this person does, whether it's financially, just connections that this person has, to get their name cleared and to be able to move forward in their lives. I will, if we ever see another child like similar to the one that I had to remove, and if you pay attention to my trials, you'll figure it out. If you do, but don't say the name if you do, because that name will not be spoken. Here, they did not say I couldn't say the name. I'm just not going to. So I hope all that makes sense. But just in fairness to everyone, if we do a smaller trial in one of these other courtrooms that we watch that do trials every so often, and it's a not guilty verdict, then I will probably take it down, so then that person doesn't have to worry about it being out there from me. I don't want to be responsible for that. So I hope that makes sense. And I think I can probably safely leave it up for like a week afterwards, because this one took probably a couple months maybe before they got that ball rolling. And it wasn't just me. The judge, she actually had a ruling against her, and I didn't want to go down that path. So I'm not going to. But that is why I kind of ended the show very abruptly Friday, and I feel bad. So yes, thank you, Gabby. Please hit that like and subscribe button. I would appreciate it very, very much. Hey, Christine, how you doing this morning? Hope you had a great weekend. Today's show is going to be uh, a shorter one, so I apologize. I have got some things that I need to work on for here for YouTube. I have some things in the works that I need to kind of keep uh, moving on, and uh, I also I have a couple. I just have some things that I need to take the time to do so I can make this channel better. Yes, thank you, Super Sen. I do not have to mow Brandon's grass anymore. That is what, 7 plus 8 acres that I don't have to mow now. I can just stick with my 4. So, thank you for healing. I appreciate it. Yes, Christine, I have not watched all of your video, but I have watched most of it. It was very good. I like Jody. She seems very, very nice. So today's, like I said, it's going to be a short stream. Judge Simpson was on last week, and Judge Simpson, I have seen him like get on to people because they tick him off, and I understand it. But watching him last week, I've never just seen him kind of just being a like, I hate my life mood. And when I thought, man, he is just starting this whole day off in a bad mood. This is weird. I've never seen it. But then when I started watching the people coming through, it was attorneys, it was their clients, it was a lot of just people that I understood then um, why he was annoyed and angry at a couple of points. So we're gonna do that. Hey, Chrissy. Hey, he could have borrowed my mittens. He just, you know what he told me? I told him it, he just told me he would just go mow with nothing on behind that house that we don't like the people at. And I just like, you do whatever, you do you. I don't live there. So, um, one more thing before I get started, because I was kind of waiting for you guys, kind of waiting. We're kind of in, I feel like a weird little trial lull here because the only things that are going on seems to be Chad Daybell and Karen Reed, and nothing else is really happening with Morton's, Mittens, Chrissy. So I'm wondering, I know Stormy wants to watch it. I know Gabby wants to watch it. Of course, Gabby says she will watch uh, anything I put up. Like, I'm like, I could put Turtles Racing up, and I think Gabby would watch it for a little bit. And I appreciate that. So, what I'm wondering if you guys want to do on like Mondays and Fridays, and I'm not sure about Wednesdays yet. Maybe I'll find some turtles racing. There's turtles over at Brandon's. We can do it live. we can. I'm telling you, uh, don't tempt me because there's not a lot going on in trial world right at the moment. I can go. There's turtles at Brandon's. There's turtles crossing the freaking road in front of me all the time right now. I can just go make them race. So if you, if you want it, I can probably make it happen. Um, but so I'm wondering, like, if and it would take us a while to get through, and then if anything happened, we would have to, of course, put it on the back burner and then pick it back up. So I don't know if you guys like on Mondays, because I know you guys want to watch the original Daryl Brooks trial. I know some of you have seen it. So on Mondays, if you want to, we could do Daryl Brooks on Monday, and then I'm thinking maybe on Fridays for right now, um, we could do the Zachariah Anderson case, the Zachariah Anderson trial, because that's a really important trial, and I'm not sure how many of you here have seen it. Um, so let me know what you guys kind of think about that, because there is a weird time here. And you guys are talking about drinking and ice cream and not listening to me. Are you listening? Don't make me get my mom voice out. It's too early. So I don't know. Let me know what you want to do. And we'll do it. But like I said, even if we do that, if something comes up, we'll just um, pause those and do whatever that is. There's also a trial. It was on Law and Crime and Court TV. I didn't see it, so I don't know if you guys did. It was out of St. Louis, I think, like a year ago, about ugh, gosh, a stepdad or a dad that was accused of unaliving his disabled son, and um, I did not see it, so I don't know if you guys saw it. Like I said, it was a year ago. Long Crime had it, and Court TV had it. I never saw it on there. I saw it off the station in St. Louis. So that's also a possibility. I can already tell this one's going off the rails already. It's early. So, okay. You guys just let me know what you want to do and we'll do it. Um, I'm going to try tomorrow, if I can, to. I I don't know what it is Monday. I'm going to try to record. I'm still trying to figure this out. Um, Judge Sour Patch, Judge Fleischer. If I can record that, I will. So that way we don't have to, because I can't pause it. I can't pause his feed, and I know it's a problem. But if I can record it, then I can pause it. I just need to figure out how to do it and make it be okay over here as well. Bree, if you're out and about, stop at my dad's. He's got some cookie dough ice cream. You can have it. If I remember tomorrow, I'll grab it. Or you can grab it on our way home from dinner tomorrow night. Yeah, it sucks. I wish that Judge Fleischer would get a YouTube account going and leave his live streams up, because not all judges do that. And I wish that he would get it. So leave that live stream up so we can pause it, we can watch it again, whatever. He's very popular and he would do very well. But I don't control the man. Nobody controls that man. We might be able to bribe him with candy, though. That is a very good point, Chrissy. Tequila lollipops. Maybe he'd like one of those. He talks about them. I saw some Sour Patch Kids yesterday and I thought, oh, I need to buy those for the next Judge Fleischer stream. I'll just put them up there. All right. So bear with me today, because we're not watching the whole day of Judge Simpson being in a bad mood, because not everybody was interesting. My goodness. I looked in the mirror before I started and my hair was fine. And then it's like somebody just came behind me and ruffled it up. Cookies and champagne. Yummy. Sorry. There it is. So you'll have to just bear with me as I kind of skip these. One of these days I will learn to edit, but it's not today. Stop doing this. Oh, and just another thing that happened while you were gone, Stormy, my phone logged me out of my Wi-Fi and it won't accept my password. So also blaming you for that too. Just so you know, Stormy. It's everything was your fault last week and everything went weird. And so welcome back. Don't go away again. All right. So I'll tell you though, this ends on a good one. The whole stream will end on a good one. I didn't watch the end of it, but I've seen the beginning. So, and was Judge Simpson mad? I know, Stormy. You can't go anywhere. Just FYI, that's the law now. That's what we've decided. Them's the rules. All right. For some reason, I have a feeling this is not going to work, but we'll see. Oh, good. She's going on a cruise in September when Ty's trial is. Good. Good, Stormy. Great. Perfect. It better work out better this time. No streams in September. Just so you know.
Courthouse case, People versus LaShawn Covington.
We know how the sound is. I have everything blasted.
Thank you. What are we doing? Go ahead.
Your Honor, this time the people will be requesting the defense bond be modified to the original 100,000 cash here passed at arraignment. This defendant failed to appear at he was also out on probation for had stopped and picked up 2 felony errors, I believe. And I believe in this case he was released on May 7th, and it showed on actually still has a for a BOP. Other non-support warrants. And people believe that in this case, the bond would be appropriate at 100,000 given the serious nature and concern for the victim's safety. In this case, the victim and the defendant their daughter, the victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to load around. Pointed it at the victim and also at their car that their child was in. The victim was in fear for her life and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, cut above her ear and blood on her shirt. These were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic violence. So we asking that the bond set at 100,000.
Response. How did he come into custody?
I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I had a case. I came out here. I got discharged off of probation. I have to stay in Washington County for several years. So when it's came in,
So Attorney has hand on shoulder, like, shut up. Oh, and bailiff's reading the room. I don't know if you noticed, but Judge Simpson's bailiff was like, I'll go stand over here. Might be predicting the future.
He was picked up originally. But I think that this second attempt at bond increase, second bite at the apple. He was released. He's coming to court today. He's ready to.
But hold it, while he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, with a judge slave's court.
Those are support cases, if I'm correct. Good.
Or it might be on 14. But our notes had that he had a video hearing on 5/2, judge said.
The initial was a failure to appear when we were before the bank. I did that arrangement for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court came through.
Hold on a second, because back, just looking for a date on this, I don't know that the defendant just didn't come into court.
Oops.
He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washington County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that.
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th. And he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, and other people looking back at our notes, what we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
correct.
So he's in bench warrant status for over a year. And obviously there's something else, other contacts with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in dental status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for preliminary examination.
Correct.
This, our lawyer informed me that I have a case in Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw it one time on the camera. So I was.
It wasn't my preliminary examination.
Because I was in the hospital, so technical reason for the computer.
No. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says that all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're gonna pick up the phone, you're gonna call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off of probation. Judge bear with me because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I'll promise her you won't come back and take care of this because I need this time. I lost my whole day, as you can see. So,
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up. And that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded.
Thank you.
I told you the bailiff was reading that. I don't know what he expected. We haven't seen him for 10 months. Did he keep saying I lost my neck? I know he was saying he lost his larynx. Voice sounds pretty good. But I thought he was saying I lost my neck. Yes. Yeah. I don't know. These judges aren't stupid. I think they wonder why some other judges do things that they do, like, but he certainly didn't put her down, Judge Perry. Which I'm not familiar with Judge Perry, but yeah, it's like I knew he was going bye-bye when I saw the bailiff move behind him. he he knows Judge Simpson. He was like, I'll go stand here so we can get him into custody. Let's see, let me make sure. Yeah, nothing else happens here. Like I said, there's some that aren't super great. There's some that start off kind of slow, and then it's like, oh, stop that. I'm going to dance around it. All right. And then they pick up and you're like, well, that escalated quickly. And he just has a
Your
look
name,
on
sir.
his face. He's putting up with no crap today.
What are we doing?
That's this matter for preliminary examination. I would ask the court also to consider a bond.
Discovery complete on both cases. People have their witnesses available the 21st. Preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. That's the bond.
Your Honor, it's my understanding that the complaining witness of this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls. He indicated he resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin, personal recognizance bonds. We have to comply with the tele requirements that court felt that if they were necessary. The allegations in these cases are not particularly aggravating. There's been, to my knowledge, no indication that he's had any contact with complaining witness since he's been incarcerated. So I would ask if the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his both of his jobs.
Well,
I first want to note out the gate that he has bonds denied at the 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24 F5 5094. In the attempted home invasion, he violated a no contact order founded on the defendant's work or founded on the victim's work causing damage to the security. And it was so loud that it caused neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, he contacted her multiple times, resulting in aggravated stalking charges. But one of note which gave us concern is on April 26th, saying, I don't know if I can ever forgive you. God is going to really have to help me through this time. He violated a no contact order.
All I have to say is if you're listening and not watching, you are missing out because his expressions are priceless. He's so mad right now that this guy's asking for a PR bond with all the things that he has going. If they are true, he shouldn't be anywhere. But Judge Simpson's expressions are, they're just writing the story of this, what's going to happen.
Victim about what he was allowed to do and appeared at her residence in violation of no contact. So it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we have requested 100,000 on each of these files. On the attempted home invasion, you were only given a $5,000 bond, and on the aggravated stalking, you were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
Your Honor, the text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, the only allegation that suggests that he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been or so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.
Thank you.
Court calls.
I'm sorry. He waited as long as he possibly could to just slam that folder down. Be like, I'm done. I'm done. You could see him. He's just like getting to the boiling point. Okay, so this guy, his case will get recalled, and we will see it get recalled. So don't worry there.
Case, People versus Michael DeBella.
This guy coming up, not this last guy.
You cannot trust the people.
He already
What's
looks.
he doing outside?
Sorry, how you have Mr. Develop. So. We're here for a plea today. I submitted the advice of right standard.
Plea form that I have before me is that he's going to plead to attempted resisting and obstructing the 1-year offense. On his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Savage point. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor, punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. I do believe we're $1,000 fine plus court costs. You understand that, sir?
Yes, Rob.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any questions regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are a part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Anybody promise you anything other than what's been stated here today on the record? Anybody threaten you or coerce you? Doing this voluntarily of your own free will? And because you believe that you're guilty of this offense? January 22nd, 2024, at the location of Westmoreland and North Wallace in the city of Ypsilanti, Washington County, state of Michigan, did you come into contact with a police officer on that day?
In my rear view, yes, it was reflection on correct.
Yes.
What happened?
What happened, horrible error of judgment, Your Honor, Lions euphoria, just horrible. Yeah, I supposed to home, thought I could get home, make terrible error. Yeah, police were behind me and,
Did they turn on their lights?
at one point, yes, Your Honor. And then
Did you stop?
I did not stop.
Did you know that they were giving you a lawful command to pull your vehicle over?
At one point, yes, Your Honor, and then they turned the lights
So you're saying you didn't resist them?
on. I did.
You know what, counsel, you're gonna talk to your client. I'm not taking this plea if he wants to play around and give excuses for everything. I'm done. I'll call it back up. You talk to him. Court calls the case, People versus Clement.
Did that make you think of the DA we watched on Friday? Could you see him asking her those questions? I wish I could, because it would be funny. Did you think those were? I didn't think they were for me. They turned their lights off. Also, I am the DA. I have a badge that says so. All right. He will come back. We got a couple in between. This guy down here in the corner that you're going to see on the Zoom call coming in by Zoom is super annoying. He's not even talking. He's just fidgety. I think that he did the right thing by not accepting his plea because he was messing around. But yeah, this guy on the bottom is going to drive you nuts. Yes, that's. I wish she would have to stand in front of Judge Simpson, Judge Boyd, and especially Judge Fleischer, and give her argument of why she did not stop, because she had no excuse. Zero. This one, Judge Simpson smiles.
Court calls the case, People versus Shantez Evans.
Yes, Stormy, she will prosecute herself.
This is prosecuting attorney working for us on behalf of the people.
Hey, what are we doing?
And we were still up the second.
Signed a waiver form? I do have it, okay. Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it? You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendants bound over on count 1 with 2 and 3 following. Ms. White.
As you already know. Stand you to wait for reading of the information is there.
Defendant having waived for reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
July 10th at 1:30 for Judge Conlon.
July 10th, 2024, 1:30, Judge Conlon. Bond continues with its conditions. Thank you.
Here comes the funny part.
I'm not sure.
It's what? What about it? It's about to die? Did you charge it?
Yes. Thought I was charging him when I was sleeping, but when I came in, they said charge.
Okay, and you're telling me why I don't have a charger?
I don't know. But I was just like,
You were letting me know in case something happens,
you know.
so that we don't run out and grab you when it dies?
You want a record.
Oh, is that what this is? This is a record? Seems like premeditation to committing an offense. Go and get it charged. All right? Sit there and look at it. Make sure it's charging. All right? That's okay. I'm gonna let Judge Conlon know. Or is it just, yeah, I'm gonna let him know. His tether probably died. What? Bless you. All right, young man, take care.
But wait, there's more.
Court calls the case, People versus Vincent Lambert. Is that your mom? Your grandmother? She told you to say that, didn't she? No. Yeah, I'm sure they did. Young man, if your charger's having a problem, since you're down here, stop over at Community Corrections. Don't want that thing to die on you, okay? Thank you.
And that was one of the few smiles that Judge Simpson had that day. That's how I'm used to seeing him. Not grumpy, super grumpy. I don't blame him so far in everything that we have seen, but super grumpy nonetheless. So this girl that's up here, or woman that's up here in the right-hand corner on Zoom, she's going to kind of pop in and out. She was just as bad about moving and not sitting still as that guy that we just saw, but she was kind of worse. She was she was stretching and fixing her hair and her phone. And I thought, Judge Simpson, most other judges would have told her to knock it off by now and to sit still. They don't allow them to walk around. He doesn't allow that. He'll tell them, like, one guy got on here earlier, he was smoking. So no smoking, walking around. Don't wear your bathrobe like the woman did last week. And that judge just laughed at her. I'm like, she's in her robe. She's not ready for court.
And that human sort of system public defender.
This is Kirsten. I always want to.
Your Honor, we were going to request a short adjournment to discuss plea negotiations. Also, I was going to discuss,
You were going to or are?
I am going to discuss a potential bond violation. For this court.
Go ahead.
Your Honor, Ms. Heeran has been arraigned on this matter March 18th. Up until this week, it's been in compliance with the bond conditions. It's noted that she has had police contact out of Lucas County in Ohio, and she was arraigned on that matter and called me right away. She let me know exactly what had happened.
Which was what?
She was arrested for, I believe, a resisting and obstructing charge out of Ohio.
While on bond on this case.
Right there.
Go ahead.
So, Your Honor, she called me. I was one of the first, if not the first.
Mr. Allen, you might as well stay right there.
And she let me know that, she let me know what happened. And that her tether was taken off. And because of this incident, I told her to reach back out to community corrections, contact her supervising agent, see if she can get her GPS tether back and reinstate it. She did that immediately. Spoke with Agent Levitt. She drove here to get the GPS tether back and put on, and she wanted to appear today here physically in person, in front of the court, to show the court that she may slip, or she made a mistake here. She slipped up. She's trying to do better. So she's only 20 years old. She has a clean criminal record. I checked, to my knowledge. She just got her state ID. She's working on getting a job. She has her family here that drove her to court. So I was just going to ask if you would respectfully consider allowing her to remain out of custody while this case is coming.
When I let her out of custody, May 28, 2024, right?
May 18th.
May 28, or I'm sorry, March 28, 2024. Right? I let her out of custody. with the GPS.
Correct.
He lasted a little over a month.
That was Judge Simpson's
Anything,
disappointed.
anything else?
I was hoping that the court would consider how she responded to this setback by getting her GPS back up and reinstated, by showing back up to court. And this is the only issue she's had since she's been on. That's all I would like the court to consider. And her clean criminal history.
Anything from the people?
Your Honor, the only thing that I would indicate, I would acknowledge that I don't show convictions. What I can say though is in the Pittsfield Township Police Report, when he responded to arrest Ms. Heron and assault, the police, and they note this in the report, that they know Ms. Heron has a violent police report. I'm not seeing anything in the criminal history. For whatever reason, Pittsfield Township Police was familiar with this defendant or her behavior towards police. And when they went to arrest her on the ag assault, she ended up fighting with 4 separate township police officers. They attempted to arrest her. And candidly, in the report, there are things that strike me as potential mental health issues based on the defendant's behavior. Not only was she fighting with the police, but there was some elements of self-harm going on. Yes. I have concerns for the defendant's safety and his safety.
And then she's down in Ohio, and my understanding is, counsel, that she's picked up additional resisting and obstructing charges.
Correct.
Anything else? What do you want this set for?
I was just gonna ask for an adjournment to discuss the negotiations with the people.
Probable cause conference will be adjourned to May 16th, 2024, 9 a.m. That's 1 week out. Given what the court has heard, defendant's bond is revoked, defendant's remanded.
You know, last week was not a good week for people to come into court and be able to walk out. Remember how many people Fleischer threw into jail Friday? It's like, you're spending the weekend. Now, I don't know if you were seeing it or not, but the bailiff, he was kind of interacting with somebody back in the gallery. I think this is the time. You're going to find out why here in just a second. And then the case that I said would be recalled is coming up.
Court calls the case, people, well, they're not there yet. They got. Court does call the case, people versus Shanala Legion.
Maybe this wasn't the one.
Thank you.
You're going to take time to the probable cause conference as the probable cause conference.
Discovery is complete.
Sorry.
People have their witnesses available the 21st.
This was
Preliminary examination will be set in person for May 21st, 2024, 9 a.m. before Judge Valvo.
Your Honor, may I approach this?
Sure.
Sorry, that was not the one they're going to approach anyway. I know I have it. I know I saved it. So I won't ruin it because he's going to yell at somebody. And I don't want to ruin that for you.
With the exception of the one you just passed, the rest of your recalls.
Court calls case people versus Lakita Johnson. That was the one I just did.
Yeah, not yet.
Never not that one. Court calls the case, recalls the case, People versus Michael DeBella. Hold on one moment before you come up. That was her. She was taking pictures in the courtroom. Why were you taking pictures in the courtroom? Because you're not permitted to do so, ma'am.
I wasn't taking, I was zooming in to try to read the sign. You can check my phone.
Check her phone. And if there are photos taken in here, then confiscate the phone. DeBella.
Your Honor, Assistant Public Defender Diego Alonso on behalf of Mr. Bella. Mr. Bella's
Michael Bill.
All right, we were in the middle of a plea that wasn't going well.
Or Your Honor, we are on the same page. I know we are.
January 22nd, 2024. If you could. January 22nd, 2024.
In case you didn't catch that, she was not taking pictures. There was no pictures on her phone. Can you imagine having your phone confiscated and not being able to like get anything off of it? I would be lost. I would have 0 numbers because I don't know anybody's number anymore. Well, I know a few. I know my family's for the most part. But yeah, she was good. But Judge Simpson was in like, no, he wasn't messing around.
Westmoreland and North Wallace, did you come into contact with the police?
Yes, Your Honor.
What happened?
Pulling over and I fled.
And you knew they were intending to pull you over? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Just one follow-up question.
Yes, go ahead.
This is coupled with the but I just want to confirm, you there, a police officer doing their job. Is that correct?
Yes, yes.
All right, thank you.
We'll accept the defendant's plea of guilty to count 1 is dismissed. Pre-sentence investigation and report is ordered at 14:02. Sentencing in this matter will be July.
June 26th at 10 a.m.
Seriously? All right, never mind. June 26th, 2024, 10 a.m. 10 a.m. Ordered by bond continued.
June 26th is also the day that I'm kind of hoping that Dill goes into labor and has Madison. Only if her last ultrasound this week goes great and Madison is still measuring big like she has been, which means she's ready to come earlier. That's the day I'm pulling for. If anybody cares.
No, because I issued a warrant on that. Calls case People versus John Obuch.
Chrissy, I would say after this week, she has an ultrasound this week. Let's see what's happening and see if she tells us it's okay to start taking bets. So that's still Madison, supposed to be a July 4th baby too. I don't think she's coming this week, but she could be. I think she'll be here sooner than July 4th.
With who?
My client.
Go ahead. It's gonna take a while.
It should not, Your Honor.
Well, go ahead.
All right, so I'll just tell you, these guys are kind of going to confer, and the reason I didn't fast forward through it is because Judge Simpson's expressions are again they're writing the story.
No, it's done from the forensics, and he's refusing to appear. So those are easy.
No red, refusing, yeah.
I mean, he's already shaking his head no. I'd be like, I saw him shake his head no. Whatever, I'm good. Just damn me my punishment.
Is he held on anything else, counsel? He's held on other cases?
Yes,
You're trying to work out a plea agreement on this case,
which involves the other cases like.
which are not before me.
No,
So why wouldn't I adjourn this out as opposed to passing it so you can fully discuss it with him? Because the other cases aren't up today, are they?
Honor of brief adjournment would be excellent. Well, no, we would like to go. Oh, my client now that he no longer with the Butler would like to know that in fact that counsel for people that any witnesses present is asked to no contact or be lifted.
So what do you want me to do, counsel?
You're requesting the be lifting of the no contact order pursuant to your request and understand being made by the complaining witness as well for a brief adjournment.
Okay, somebody's going to explain to me about the complaining witness. Why is, go ahead.
She is present, she has already let the human rights advocate know in my office that she's requesting no contact order be lifted. I told her personally in court today, I am not making that request, but to be candid with the court, I turn that information over to public defender should they want to make that request. I am not in support of this. This is one of many cases that have come through my office regarding this domestic relationship. This is not the first time that we have received calls about stealing her car. I understand that she has a want to support him moving forward. But he is in a position where he needs to focus on his sobriety first. And perhaps later there would be a safe place for these two to communicate, but this is not the time.
Anything else?
I'll leave it to the court discussion.
Well, I would normally hear from, I'm adjourning this out 2 weeks so that you can figure out what the whole thing is. I need a whole picture of everything. Ma'am, I will, did you wish for me to hear from you today or I can hear from you in 2 weeks? Wherever she may be. I don't know where she is. Did you want to talk?
I didn't even realize that she was with the picture or the lady that they thought were taking pictures. So Chrissy, the way this switches around, I think is automatic. I'm not sure who controls it. But yes, I do understand. I'll be curious what your guys' take is on what at the end of this.
Talk to me today about this or in a couple of weeks? That's, I know she didn't tell you that. Hold on. Can we move him there? And I need you to come up to the podium.
So if you didn't catch it, he's in custody. There's a no contact order. She is there. She wants the no contact order lifted. The state does not want the no contact order lifted. And she's coming up to tell the judge why she wants a no contact order to be lifted between the two of them. And the state is saying there's been too many domestic DVs between the two of them for them to be able to get behind not having that order in place.
Pardon? No, I don't, no, just come on up, man. Hello, what's your name?
Um,
Okay, what do you want to tell me?
So, well, I know that I didn't cause why he's here right now. I know that it's not my fault, but I've been in this like any families like for over a year now. And I do feel like I have been a support system. It's been rocky, but I feel like I have been a support system and I feel like the best thing for me is get treatment and to get help. Like I don't feel like sitting in jail is the best thing for anybody. And I do feel like he really wants to be like the man that he and his family cares about. And, you know, I work every day. I do what I gotta do. And I don't want him to think that I'm not in his corner. I am in his corner. I do want to see him get better. And I want to be there for him. With a no contact order, I can't even talk to him, like how he's doing or like anything. So I didn't ask for it. I understand that. And I'm talking to other people. It's just something that happens when something like this happens. But I don't want it. I want to be able to communicate and let them know that there are people that are positive influences in his life that are there, want to see him do better. And we are going to be here to be that positive that he needs in his life, and not that negative that he has had in his life. And I know he suffers with grief and loss. And 2 weeks ago, he died. And while it's not an excuse for his behavior, it definitely hurt in that downward spiral that just happened. And I just don't want anybody to think like I'm trying back on this. I'm not. Thank you for letting me talk.
No, not a problem. Listen. I have to listen to a lot of people, and I have to listen to people who may be victims of things regarding no contact order. And so I don't know why, maybe because of what you said, you don't want anybody to think you're being supportive. But those that come before me, you're probably one of the most supportive that I've actually heard from. And the reason for that is that you didn't just try to say everything will be okay if I do this. You acknowledge what the struggles are and that he needs treatment. And that then you can maybe be able to step in and guide him. That's what I'm hearing from you. And that takes a lot, ma'am. That takes a lot of courage to say. Okay. So here's what I'm going to do, and understand something. What you just told me, those said different ways, and what Ms. Hughes just said are really the same thing in a lot of ways. Okay, because I think what really she was saying, I would like to see also is that the relationship be healthy, but that it can't quite get there, not because of anything you're doing, but because he needs treatment. Okay. So what else were you going to tell me? And I didn't mean to interrupt.
I just like when it comes down to like, treatment and stuff, like I told him that like I would go to a class with him, like I would sit with him, or I mean even like through my work, because we have the same address, like I have benefits that are available for that kind of stuff that are free to in the household. But I don't need it for it.
Okay. Listen. Take a pause a little bit, okay? Because it's been rough, I'm sure. Okay. And realize that all of that can't be set up sort of all at once. I'm glad you said that about what might be available for him in terms of some type of treatment, because that's good for his attorneys to know. Okay. So what I'm going to do today, I'm going to adjourn this out. I'm not going to release him today. I'm not going to change anything. but I'm only going to adjourn it out a week. I'd suggest that you, to the extent you're comfortable, get to the public defender's office, let them know what may be available for him, right? Because that may help me formulate either some type of release scenario or some contact type of scenario. Okay, because I'll have more information. Fair enough? Okay, if you want to be here, can you be here in a week? Okay, then I'll set it then. All right, thank you, ma'am. Come back up. All right, what I'll do is I'll adjourn this probable cause out 1 week to the May 16th, 2024, 9 a.m. And at this point, I will deny your request for any change in bond or any modification in bond. This bond will continue for the reasons that are stated on the record. Okay. Thank you.
I don't know. It's probably just me, but seeing when judges get very human and sympathetic, empathetic, whatever, towards people, that's like my favorite thing in a judge. Sometimes they deserve to have the hammer brought down on them, and that's also one of my favorite things in a judge. But I was when she started speaking, I was kind of like, I don't know that you should, but then I was understanding kind of what she was saying of she understands he needs help. I hope she understands that she can be supportive, but she's not the person to give it to him. She can help him get help, but she can't be the help, if that makes sense. I don't know. Maybe you guys have a different take on it. All right. Stretchy's back. And she's interesting for a minute too.
Thank you. All right, what are we doing? Why not? Where is case discovery complete?
It is.
People have other witnesses available the 21st. Any objection to that?
Yes, I may rely on my bond request.
Oh, you want to negotiate? Well, go ahead.
Your Honor, I am asking the court to consider a release on a personal bond. Mr. Polisky has no violent criminal history. He was employed full-time at the Manchester market as a butcher. He was actually arrested there. I say that because the incident where this alleged to have happened is his residence. He is either there or at work. I know that this occurred back in January, but he had no knowledge of the warrant issuing. And so if he had known, he would have turned himself in an earlier date. He's been in custody 10 days. No objection to a GPS tether being placed, whether that's to keep him on a home confinement or to ensure that he does not go anywhere near this complaining witness in the matter. I'm asking for a personal bond.
Response.
Your Honor, at this point, the defendant has only been in custody for 11 days, and this did occur on January 3rd, 2024. As defense counsel just mentioned, he did not turn himself in on this. He also has a hold out of Oakland County. But most concerning to the people is the nature of the allegations here. This is a strangulation case. It started as a verbal argument between the defendant and the victim about the defendant's drug use. It did, as defense counsel mentioned, it did happen at the defendant's residence. The victim started to put on her coat to leave when the argument got heated, and that was at the point where it escalated into a physical altercation. The defendant pushed the victim to the ground, tried to grab her by her coat collar and slapped her across the face. That wasn't enough though. He then grabbed her by the neck with both hands, choking her. While he was choking her, he then pushed her outside and brought her down to the ground again. At that point, she was struggling to breathe. During that time, the defendant said to the victim, "Fuck you, bitch." And then the victim fell to the ground and he stomped on her chest with his right leg. She got up and ran to her car and started calling 911. It was at this point that the defendant kicked the victim's dog out of the house. At that point, she rolled down her car window so that she could call her dog to the car. This is when the defendant took advantage of that situation, reached in her car window and took the phone from her, preventing her from completing the call to 911. At that point, she was so in fear that she left her dog at the scene and drove away. She drove to another residence so that she was able to call 911 and had to return back to the scene for her dog at a later period. I'm extremely concerned for the victim in this case, and I would be objecting to any modification of this time. We did request 25,000 cash for surety, and we were given 25,000 cash for surety at arraignment.
Your Honor, if I may speak to a few of the people's arguments.
Sure.
One, he did not turn himself in because he had no knowledge of the warrant. He did not try to flee the area. He's been living in Manchester, the address where this happened, and working at the same location. As the allegations, he denies them in their entirety. And Your Honor, his lack of history is no assaultive, any form of assaultive charges. And if this happened in January, there's no new allegations. He says to me that he has not spoken to her since this date. He has no reason to contact her. And I think that on the basis of him not looking up any new charges or anything related to this woman since January, go to show that he has no intent to contact her upon her release, upon his release. And so I'd ask the court to consider a personal bond.
Well, here's what I'm gonna do, given everything. I'm not gonna give the additional week. It'd have to be the 21st. So I'll set it for May 21st, 2024 at 9 a.m. Motion for bond reduction or modification is denied. Bond will continue. That preliminary examination will be before me on the 21st. Thank you. Ready. Court calls the case.
Sorry, looking at my own notes. Sometimes I can't read my own handwriting. Did anybody not see that coming?
Versus Wayne Shaw.
Stop it. I mean, sorry, they took a break. Judge Simpson is very good at taking very long breaks at weird times, too, sometimes.
Court calls the case, People versus Jacqueline Nemasek.
Under dog, you don't have to check.
I'm here.
Can you state your name, ma'am?
State your name.
Jacqueline Nemechek.
Thank you. I have before me a plea form. Indicates the defendant is going to be pleading guilty to the charge of use of a controlled substance, that being methamphetamine. And that's count 2. Count 1 would then be dismissed, and it's okay to seek 74 of them. That's the court's full understanding of the agreement, and it's obvious that Childers wrote
Correct. If I ever had any problem, I'll be unable to review.
this. Yeah, this is a struggle. All right, very good. That was the correct statement.
It was.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Jacqueline Nemechek.
All right, you can put your hand down. All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of a controlled substance, that being methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
Still wish to plead guilty?
What was the maximum sentence for jail time?
The maximum is up to a year incarceration.
Okay, yeah,
So you want to plead to this charge?
yes,
All right. And to that charge, how do you plead?
guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, man?
yes, and this is for the plea deal, right?
That's correct, Ms. Nemecheck.
You understand what you're doing right now, right?
Yes,
You understand that you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
I'm on probation in Toledo.
All right. Were you on probation in March of 2022?
Yes,
All right. I need you to understand that if you're still on probation, that this entry of this plea in this case could be considered a violation of that probation.
I know,
You understand that?
Yes,
Pardon?
yes, they already probation violation me. That's how I figured out I had a charge in Michigan. I didn't even know.
All right. I do have to advise you that because of that, I don't know what they've done there or whether or not they've taken care of it. If it is considered a violation, they could sentence you to the maximum allowable under the other charge or charges. You understand that?
Yes,
All right. You still wish to plead guilty to this charge?
yes,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
no,
Anybody threatened you or coerced you?
no,
You're doing this voluntarily and of your own free will?
yes,
And because you believe that you're guilty of this offense?
yes,
March 26, 2022, at the location of the Comfort Inn on State Street, City of Ann Arbor, Washington County, State of Michigan. Did you have methamphetamine or ecstasy in your possession?
okay, so like, if I say that I was drugged and that,
Ms. Nemecheck, if you'd like to accept the offer, it would be a yes or no answer to that question.
yes,
I agree.
Was that yes in answer to my question?
yeah, sorry,
And had you used that drug?
yes,
And did you know what you were using was that drug?
no, but I didn't know it had methamphetamine, but yes, I guess.
Okay, so what did you think you had?
Well, I didn't know ecstasy had methamphetamine in it, but
Five? What?
I said I didn't know ecstasy had methamphetamine in it. I really
Okay,
did.
but you had a drug known as ecstasy, correct?
Yes,
And you knew that that's what you were using.
yes,
Okay. Counsel, have I complied with court rule? Would it be proper to accept this defendant? Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
24th at 8:30 before Judge Perry.
May 24th, 2024, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you.
Okay. I was surprised he actually took her plea because he didn't take the other guy's plea. Now she's not in court. Had she actually been in court, not by Zoom, but he could have put him in a breakout room because her attorney's in court. He maybe should have sent them out to meet, and so he, the lawyer could correct her because she was kind of like, I don't know if I want to do this. To me, that's what it seemed like, and I was really, really surprised that he took her plea deal. I'm glad I'm not the only one. Thanks, Chrissy. Because that one was more strange to me than the other guys. And he wasn't about that. So I don't know. But again, poor Judge Simpson had a very weird day. And I'm just going to say it, even though it's this week. This happened last Thursday. So, Stormy, it was your fault. Just so you know. Judge Simpson's very, very strange day. That's on you. No more cruises. Until September, apparently. I had to do it. All right, we're going like almost to the end here. Don't worry. It's not over yet.
All right. And there has been a motion. I've received a response. Is there anything additional? Go ahead.
Connor, I just believe that in this call, it's very important to look at all kind of pieces. It's really vivid, super relevant to my wrongdoing, and kind of look at separate parts. At the beginning of the call, it starts off with the defendant telling her that she wants her to not testify against him. And at the beginning of the call, the victim doesn't want that and wants him to be held accountable for his actions. He says, like, I didn't want to do that, but what you did was really fucked up. He says, I want you to do one thing, you just only one way to be testified here. He cannot testify against. She responds, you should have thought of that, but I didn't do anything, not that anybody would, cause anyone to do that. She's telling him she wants to be held accountable. She's scared of him, terrified of it, about what happened. And he keeps pushing, like, as the conversation continues, he keeps pushing the issue, telling her, tell them that you lied or something, this shit's fucked up, this shit is fucked up for real, I gotta get back to my child. And he keeps pushing and pushing throughout the conversation and blaming her for the situation. And she keeps telling him she's terrified, she wants to be held accountable. She says things like, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. Keeps pushing her and saying, what you're saying and this shit could have been fucking up my case right now. With that being said, I don't need you testifying against me in this shit. You do come, tell them what you were saying is a lie. And she eventually, throughout this call, begins to break down, is in tears, and finally agrees to do something about it and not testify now. Because of the continual pushing and conversion this kind of did, and blaming her for the situation, trying to make her feel guilty of the situation. And you can see throughout the call that he wrote her down to agree with his own opinion from the call and not come to court testify against him. It's a very vivid portrayal in just one call of course and breaking her down throughout the call, not testifying.
Ms. Gaines.
You know, I would like to start with, and perhaps we can approach and look at the file to see now it has received service that the complainant has been served with, or otherwise notified of this, that there was in fact a hearing previously scheduled for a matter before it turned out that the person wasn't even aware or had not even been notified officially of the hearing. And so that's where I would like to start, because if there has been notice, by people of this, I think that immediately handles, that immediately addresses this situation.
Our victim advocate did reach out to the victim about the preliminary examination. The prosecuting attorney working for us on the prosecution. No, I'm just gonna handle the rest of this, but I do want to know specifically, there's a note in our file from victim advocate Spangler that she texted the victim on April 19th about the preliminary exam. It is also routine for our office to send a notice to the officer in charge to subpoena the victim. That I did send personally that notice to my officer in charge in this case, so the victim should have been was confirmed notified at least once that she was expected to attend to the preliminary exam. Contact was made and should have gotten an additional notification from law enforcement about that expectation. So I do believe our office has done our due diligence with ensuring that the victim was notified in this case.
So starting with that, Your Honor, I would state that I do not think that indicates due diligence. To send a text message, it is not unusual for without, because there has been no indication of a confirmation of receipt of a text message. Without that, we don't know that it's still your phone number, if it's an error in the phone number, we do not know if that actually got to her. Second.
Well, why wouldn't that constitute due diligence? I mean, in light of the phone call, which has to be, quite frankly, in doing this for a bit, one of the most egregious of phone calls to a victim in the case. If I follow your argument to its logical extreme, what would happen is the defendant or a defendant could make a call like that. The victim, out of fear, or alleged victim out of fear, could change her phone number. The prosecutor only has one way of contacting. And then, but they send the message. They also contact law enforcement to make contact with the alleged victim in the case. And what if it's somebody that just, at that point, because of the phone call, doesn't want to be found? That doesn't go to due diligence.
Your Honor, even at this point, we have not heard anything other than that they asked law enforcement to attempt to provide some sort of notice. We have not heard that law enforcement out there, law enforcement themselves made a call, that there's any attempt at searches. I think that in fact, by not ensuring that they have actually made efforts done.
Well, you're not arguing that a subpoena is necessary. I mean, if an officer went out there and say you have that, you're not making that argument, are you?
What I'm saying is that at this point, we haven't heard that even an officer has made an effort. That is what I'm saying. I'm giving examples of what of due diligence and saying that this, at this point, we're going to be satisfied. Do you have some response with regard to the phone call itself? And I know previously in the matter I had with Ms. Grosso, she provided your time to call. I did not know if that occurred before this one. Mr. Gabby from our office was at the previous hearing. And if you have not listened to the matter, I do wish to go through the phone call in more detail, but I wanted to start with that, in particular, having had a case where the victim advocate left a message on voicemail, and that was it. And with that, there was definitely, there was more in terms of that, plus the conversation where Your Honor found that it was not, that you did not find that it was my client's fault.
Yeah, but that, but
And I want to start with that, but I also intend to address the information in the call.
well, go ahead and address the information. I mean, Ms. Sender went through what the call was. If you want me to hear it, you want me to hear it. But I mean, if you're talking about the cases that I think you're talking about, I mean, what's said by the defendant in this case is gotta be the most egregious that I've heard. I mean, I mean, it can go anywhere from just contact, all the way up to don't show up or some harm's gonna come to you if you show up. I mean, on that spectrum, this call is way on that far end of the former of what I said, the latter of what I said.
Well, I think exactly what, if you listen to what their argument was, it was exactly that you take it piece by piece as opposed to taking the whole conversation in context. And in terms of the specific, well, as one example of the specific part of the phone call that was referenced, that, I think I need to get a PPO out of me. Your Honor, that was not part of the discussion or with regard to the part of the discussion involving if she should appear and that part of the phone call.
What do you do with don't show up, but if you show up, then tell them you made it up? Basically, I'm paraphrasing. What do you do with that, Ms. Gaines?
Your Honor, I think the first part is that even if that was what was said, if they have not gotten in touch with her about what the date was, if this phone call was dated weeks before, that is not in terms of what is required, that the action actually caused the failure for the person to.
Okay, if you're gonna go harp on that, then what I'm gonna tell them is just 2 days before the preliminary examination, subpoena her. And then I can rule on the motion right now as to the conduct. And then if she doesn't appear, all of it's satisfied on the 21st of this month. I mean, if the argument is being made that the people haven't done their due diligence, which I don't think is true, but if that's your argument that she needs to be subpoenaed, they can go through the efforts and try to subpoena it. They got 9 days to try to do that to get her here. And then if she doesn't show up, they're going to be able to proceed by forfeiture.
I would have additional arguments at that time, given the length of time since there's been any contact with her, as to whether or not it's his.
Because I had to shut off the phone.
I understand. I understand that.
I mean, that's the reason he hasn't had contact. And I can't even say that worked because.
Is there some information that you have that I have?
I have a lot of information about a lot of things.
That is true, right? Let me ask a more pointed question. Let me ask a more pointed question. Is there information? Have you received information that there's?
You have phone calls from April 11th. April 11th till now. Then that means my order to restrict and revoke his privileges worked. So when you make the argument that there hasn't been any contact, it's because I had to revoke his privileges.
I wonder if she now knows what it's like to be in quicksand and arguing with the quicksand to try to get out, because I feel like she's just sinking slowly in quicksand because none of her arguments make any sense. I can't follow them either, Chrissy. She's doing a lot of word salad and she's doing what she can. She just can't do anything. He was just waiting and he just made his point. I had to revoke his phone privileges since April 11th. You had any contact since then? No. All right, it worked. Next. And he's smiling. He's proud of him. He's grinning like, where are you going to go? There's nowhere else for you to go at this moment. And she's like, I'm going to continue talking.
What you're saying. Still would want to address that if she did not hearing and was provided with this.
Address which issue?
The reason, whether or not he was the cause, his actions were the cause of her not attending. I do also though want to go back to the phone calls, that I do believe that there is a broader context to that, that the statements that were brought up about getting a PPO were not with regard to him having called her, and that these were, and they were not said in response to her, to him asking that she, pardon me, to him explaining that if she did not appear, that is how the case would be. I would also add that my client's statement of that the statement that's alleged to my client allegedly made my client that he indicated that she say something different, an alleged statement that if he said that, our position would be that he was asking her to tell the truth about what happened. And that throughout the phone call, there are references to her being disrespectful of his mother, his grandmother's home, of behavior that he indicated to her prior to her calling law enforcement, and was asking her to leave his grandmother's home was not what his grandmother or what would be found to be respected by her in that home. And so there's a lot more in the conversation than simply those statements, and that there is a fuller context as to how, as to what was being said.
And I think Judge Simpson just turned his brain off and was not listening to all of that. It was so repetitive. We got it. We understand. I don't know what you want him to do. Whatever it is, I guarantee he does not do it. He's not buying what you're selling. And he's also not giving you a tree branch to help pull yourself out of the quicksand that you have put yourself in.
Does that context change the word?
For
I mean, that's what I'm saying, Ms. Gaines. I get your argument, but I don't know how you escape the words in this instance. I mean, go ahead.
in the case law, it indicates that the wrongdoing is the use of coercion, undue influence, or pressure to silence testimony that it would include threats of harm, suggestion of further retribution. There were no threats of harm or suggestions of further retribution made during that, or any retribution made during that phone call.
Anything additional?
Cease.
If I may, just on that one note,
Yes.
The defendant was very cognizant that this was a recorded line. So whenever we got to the point of
Sorry.
there being a potential for a threat or coercion or something that was explicit, he said, Casey, listen, we're on a recorded line. Casey, listen, don't do that. We're on a recorded line. That's enough in the people's mind to show that there is something in the background there. And specifically, the defendant says, are you trying to keep me locked up? And the victim says, no, like I want to put a PPO on you because I'm scared to death. I don't know what you're going to do to retaliate. The defendant responds, I'm not no crazy ass dude. And she says, I didn't think so either. And he says, so Casey, look, we on recorded lines, so can you stop talking like that? That makes me extremely uncomfortable because to me that says that there's something more that needs to be said and he can't say it because it's a recorded line and he knows that we're listening. That is threatening in the way that it's not, he's not able to articulate it because he knows it's going to get him in trouble.
Anything else? Ms. Gay, anything else?
Just this, in terms of what the people just read to you of the statement. And how that conversation began. It did not give a response to a threat or don't come to court or else this will happen, do that, which is the point I was trying to make, to deal with, and that even if asking her not to talk about something is not the same as him refraining from making.
But at points during the conversation, he makes the statement about her not showing up. He also makes the statement that if you do show up, don't tell him what you said before. Don't tell him. I mean, he's basically saying to her, if I just were to put it in colloquial, don't show up. But if you got to show up, lie.
We would say that he did not tell her to, that what he was telling her is to not say what she said before, which was a lie. And that
He didn't say show up, tell the truth, did he?
No, gosh.
He was giving her the story.
Your Honor, he did not tell her specific words to say about what happened, no. But I will say, he did not give her specific words about what she should say.
My hair stays out of my face.
Court has reviewed, the previous courts listened to arguments on this case, and maybe this is the reason why the no contact certainly is put in place, because these particular things. As I read the comments made by the defendant in this case, one wants to give context to them. Some of them, you don't even need to have context. I mean, he's telling her what to do. I think there is explicit and implicit as well as explicit threats to her regarding her testimony in the case, regarding her appearances. He is clearly, if anything else, in the confines of this conversation. I don't know why we don't have other charges. Obstructing justice, intimidating a witness. It's clear. And as I said before, this is probably one of the more egregious of cases. I'm not pretending to hear and see everything, but certainly this is egregious. So to the extent that you want to raise the issue of the due diligence on the part of the people between now and the time that the exam's set, they could do whatever they can do to try to get her here. If she's here that day, she can testify. If she's not, I am, given what I've seen at this point, allowing the people to proceed by forfeiture, and that her testimony will come in, or her hearsay statements will come in. That will be able to proceed along that fashion.
Wow.
All right, so the people's motion is granted.
I kind of feel like this woman talks in her sleep. She was like the Energizer Bunny. Just keeps going and going and going. Now I gotta see why I let this play out a little bit more.
This matter will continue to preliminary examination on May 21st, 2024, 9 a.m. before me.
I don't really think there was any reason. I got to remember what this one is because it's split in two.
This person in custody.
Yes.
Let's get him around. Well, I don't care. I'll do this one. That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with
All right. So this is this guy, this attorney makes Judge Simpson as mad as I have ever seen him. So I don't even remember. I don't even know what they're talking about. I think it's some kind of DV thing, no contact thing. But this attorney ticks Judge Simpson off.
James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
Your Honor,
Yes, sir.
I didn't file a response because we got this at noon yesterday, but honestly, we also yesterday afternoon received discovery which we followers. There's some issues that I certainly have with the allegations contained in people's motion. The simplest one is under paragraph 8. It lists 4 offenses, criminal history. A and B is the same offense. 22821 is a district court case that became a felony, was found over reporting registered actions, resulted in a plea to operating law, the second offense, 31621. So that is one, that's the minor issue I have. Their description of what happened on this date contains, I think, some confusing statements. Paragraph 3, they say that the saw the witness the assault, but in paragraph 5, they correctly state 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10, mom says she was 11. Said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant is looking at a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When first asked whether or not he strangled her, she said, I will tell you, I will say that if you tell me I have to. This is not the case that they purported it to be. This case is more consistent with what I explained to Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
This Fink, did I say Mr.?
Sit.
Oh, Judge, Magistrate Fink, I'm sorry. You're all your honors to me. So. I don't want to get too much into the case, but what I will say is there are a huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened, because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. What's also not contained in the report is the report says that she called, the alleged victim called the police, and actually that her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years, and her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He's always has a smile on his face. Stunned that it happened. The children said, don't hear him argue, never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. We look at the factor of the likely sentence. This, I initially had scored it as 0-17, but then when I looked at his record more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanction. So it's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relationship. B2, 0 to 11 months probation. And the people are asking not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to at trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that we're using a felony, guideline scoring, off or operating while intoxicated. It's always showed up. The only history of substance abuse or addiction is what is related to alcohol use. Certainly he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous. Also, what I just said relates to the seriousness of the offense, presence, or absence of threats. And Wilson's found on that. He has had no contact with her since this incident happened. He has been exceedingly proactive. My legal assistant has been in contact with the officer in charge since this had the day that it was indicated that the complaint was authorized. She tried to turn him in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification. She shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He's an employee, he works 50 hours a week with Stanley Infrastructure. He just told me that that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here, his job's here. He has no ties to any other community. As I said, as far as the other thing, he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love him. I love all of these things. This is my fault. You only sent a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open from something that she threw at him, most likely a phone based on her statement to the police. That happened before these other things.
Go ahead.
She denied being strangled. She said that her head hurt, not because of an injury, but because she was confused. Quite honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's an upstanding citizen of Washtenaw County. The prosecutor's office is seeking to punish him by a $150,000 bond. It has nothing to do with what her allegations were at the time and nothing with what really happened. I don't see in here, I've only had, 27 hours to look at this stuff. The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. But what it does just come down to, Your Honor, is Mr. Whitley is not dangerous. He's going to show up. And he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of the daughters. The mother has it. She's never made allegations of domestic violence in the past because it didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you she doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write it. She just wrote. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, 1 for the chest and 1 for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of her intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count 1 on here is charged in the alternative of assault, GBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault, GBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I'll make it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions, some of the issues that she had.
What does that mean?
Her children, and she said this had never happened before by Mr. Whitney. Never happened before. Okay.
But I don't understand the first part of what you just said,
Well,
how that relates to this.
She may have some PTSD related to the trial before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
the prosecutor is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying.
And he's blaming an unalive dude for her reacting now. How long has he been gone? Yesterday? I mean, dang, that's pretty low. Don't worry, it's about to heat up here soon.
Okay.
And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off the bed. I don't know what she's gonna say in the statement. And what's important about this, no influence whatsoever by Mr. Whitney. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my
Call,
client's
call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not gonna happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's gonna stand in recess.
Right. Have you seen it?
If you missed it, he just accused the judge of saying the state, the people, could have asked for an emergency, that they could have asked for a hearing at 3 o'clock in the afternoon and get it, but he couldn't. That's what ticked him off. That he just accused Judge Simpson of playing favorites. But he did make me laugh how he kind of backed into his, how they kind of go behind the wall there. But he made me laugh when he did that. Yeah, he censored himself. You were correct, big time. Because you could see he was annoyed because this guy just kept droning on and on and on. And then he accused the judge of playing favorites with the people there. That's what they call them. The state, whatever. But yeah, he took a break like that guy should have taken a break. And that guy is standing there. I don't know if he did this or not, but that defendant is standing there trying to look so pathetic. It's ridiculous because the lawyer said, people that know him just said he's always smiling. I'm like, well, he ain't smiling today, is he, son? Like, he is trying to look so pathetic. It's ridiculous. It's pathetic. Yeah. He didn't like you before, sir. He doesn't like you now. I mean, you take the guy that we heard before allegedly contacting his girlfriend or whoever she is and telling her what to say or do or whatever, and that attorney's argument sucked. This attorney should have argued for that attorney because I think he may have allegedly, in my opinion only, contacted the victim in this case to write a letter that she wrote on her own. Or I did that wrong. Whatever. You know what I mean. I agree, Chrissy. This whole thing stinks. All of it. But, and to blame it on her husband that passed away, where's your proof? That's a huge allegation to somebody that is not around to defend themselves. Like, you'd have to, because they're not here. So a lot of times that stuff doesn't get allowed in because you can't question them on it. So I think, would have to have concrete proof that happened. But then you wrap it all up by insulting the judge? Smart day. Yeah. Gabby, that's an understatement for that hearing. Because, oops, I have to hit play, or we just look at a courtroom.
14A District Court, County, Washington. Session, the Honorable Judge Simpson.
You may be seated.
He's still ticked.
Court recalls the case of the people versus Whitman.
Good afternoon, Your Honor. For the record, my name is Judge Bennett. Here in this time to get Woodley is standing to my right. Will you state your name before, please? James Anastasia.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years. And never have I ever been insulted in the fashion you just insulted this court. In very, no, my turn. The case, the very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right.
Watch him walk. Watch him walk. Watch him watch that attorney walk out the door. I got it. I said it. Dang. Yeah, he is like, good day, sir. I said good day. Don't worry. I have the rest of it. But then you got this poor fellow. He's got to come up next. As he just gives him the big stare down. Like, get out of my courtroom. Hurry up. Go and get. That's what our neighbor would say. But he's not here anymore to say it.
They're bringing him.
Yeah.
He's like, he doesn't want to come, Judge. Why? Well, because he just heard you yell at them and was like, I think I'm good. Whatever. Bond doesn't need anything. I don't need Bond. I had to say it, Carmen.
Or it does call the case of the people versus Michael Deshaun Kyle. Not yet. I have not signed a motion to withdraw.
This is Matthew Mansour, Assistant Public Defender with on behalf of Mr. Kyle.
I have this motion. Well, are you ready to argue that motion? Yes. Well, I've got a problem here because I'm trying to figure out what happened on the public defender side.
Your Honor, I can explain that. I was appointed to represent Mr. Kyle on this motion hearing today. And
You mean assigned? Your office has been appointed from the get-go.
Yes, I was assigned to represent Mr. Kyle this motion today.
I have sent a conflict check to our office this week because of his new charge that he has picked up, the witness tampering charge. And while waiting for the conflict check to come back, either confirming that there is a conflict or not, I was prepping for, our office has sent email saying there's a conflict, please withdraw.
Takima LaShawn Cooper wasn't involved in the case before the other matter?
Takima Cooper is his mother, and she is a suspect in the New Star.
So why would that cause you to withdraw in this case?
Your Honor, I don't handle whether it's.
Well, somebody needs to get here and tell me, because here's the problem. As of the 4th of April, there was no conflict. Right? It comes down I think it was the 23rd of April. Then his exam is set before me. There's then a request for an adjournment. No mention of any conflict at that point.
Correct.
Then I don't get notification. So and then from that date, I adjourn his prelim. The people are going to file their motion. I give a date today for the hearing of the motion. And then the day before, I get a motion to withdraw. And by the way, no answer to the motion.
I completely understand the frustration from the court.
Oh, I don't think you do.
Your Honor, I was prepping for this matter up until yesterday. I'm just telling you where I'm at with it today. There was a conflict check that I sent this week. I was appointed to represent him today. I sent that conflict check this week. So
On the new matter.
on the new matter, and yes.
So since you're still counsel of record, what do you suppose I do with his exam?
This preliminary exam coming up on the 21st.
Yes.
Your Honor, if it was up to me, I would request just a week adjournment to allow.
That's not the way the exams run. I understand that, but I've got a motion. They want to proceed by forfeiture. Who's going to argue that?
Your Honor, if I need to, oh,
Council told me what it was about, but I have not actually been those phone calls. So I will be overnight just.
yeah, our office has jail calls, which is great.
Ms. Barroso, you've arisen.
Your Honor, the forfeiture motion is on the assault with the intent to cause great bodily harm and murder by strangulation or something, not on the intimidation. We do not need the victim to proceed on intimidation because it is based on the jail calls. All we need is the officer. I would say unless the public defender needs to withdraw from the original offense because of a conflict, that we proceed on a motion today, since he was prepping for it up through yesterday, and he responded orally on the record.
Is Tamika LaShawn Cooper a potential witness in this case?
She was not physically present at the scene, and it is my understanding, Your Honor, that the individual who the defendant called on the phone that was not 911 was the defendant's grandmother, not the defendant's mother. So she would not be a witness in any capacity in the assault she engaged. She's just a potential co-defendant in the witness intimidation, which we have not brought charges against her in that case.
How do I have a motion that tells me that this is a witness in this case? And I just heard she's not a witness in this case. She's not even a potential witness in this case.
Hello?
That was the question.
Your Honor,
You need to, you know what, Mr. Mansour, I realize how that process works. So what I'm gonna ask the jail to do is to take him back. You find somebody that can give me an answer to that. Now. Take him back.
I don't know who has the answer. I'm just glad I wasn't asked that question. Oh my gosh.
Yeah, court stands in recess.
I don't think he comes back. Oh, maybe. Do we get an answer? I didn't see this. Oh, I hope we get an answer. Looks like we're going to get an answer. Maybe not. Nope. Come on, Judge. I have to see now. I thought I saw him pop back up. Maybe he's yelling at somebody. Yeah, he's coming. He's coming back, I think. Where you at, Judge? Oh,
But in
there
the
we
case,
are. I told you he's come back.
but in the case of the people of the state of Michigan versus Michael Kyle.
Assistant Prosecuting Attorney Morgan Moroso, on behalf of the people.
So that we've had a bench conference in this case, so that we're clear, and I think the court is correct, and it's just been said, the court is not going to sign or allow the withdrawal of the public defender in this case. Ms. Ford, so the public defender is still on this case. Did you receive two requests for assignments on Mr. Kyle? I was talking to before. That's okay. I'll explain what I mean. What are the last four digits of your case number? 1225. That's the other one. Two. Got it.
I got something that said I should be here today.
Right. Partially because they had sent in the motion to withdraw on this case that's up today, which is the one ending in 1212. Right. But I'm not permitting the public defender to withdraw because there is no conflict. somehow there was some confusion. There will, I guess, potentially be a conflict tangentially, but I'm not gonna get into that, but on the other case that Mr. Kyle has,
1225.
1225. Have they made you aware that 1225 is set for preliminary examination on the 21st? Okay, all right. So if you know that, I don't know if you have discovery, they're gonna make sure discovery and all of the phone calls and everything get to you, Ms. Barroso. When we were at the bench, where she's gonna make sure that that happens. Is that correct, Ms. Barroso?
That is correct. I'm just writing down her email address for me so I can make sure you get that to her.
I should be here on the 21st.
Yes.
And you're going to hold the hearing today on the other one?
Yes.
I'm gonna just-
All right. Very good. All right, I've read now back to the case 1212. I've read the people's motion. There is no written response from the defendant, but you can go ahead, Mr. Mansell. Did you wish to respond to their motion to admit statements?
Your Honor, could I ask, Ms. Barroso for a copy of those statements, the motion?
That's my personal copy. Do you need me to email you that?
Well, hold on, counsel. So, Mr. Mansour, because of the withdrawal, which may not have been the proper withdrawal, you're not prepared to argue the motion. Would that be a fair statement?
Your Honor, I would like to have additional time to be able to prepare, so.
I think my question is a yes or no.
So, to answer that question, not 100%, but I can do my best.
Mr. Kyle. I'll let them explain to you what happened. All I know is we had set this, and I'm sure you recall you were here before me on that date, and I gave a motion date. People were supposed to have everything in, and that was going to be today. And then you have your exam set later in May on the 21st. What's happened, and I'll just explain it I'll let everybody else fill in the details, okay? But I'll just say, yesterday I received a motion for the public defender's office to withdraw on this case, right? My understanding is it was only supposed to be relative to your other case. Got it? So from what I'm understanding from what Mr. Mansour said on the record earlier, that he's preparing to handle this motion that I have set for today. But then once he's apprised and he doesn't make that decision that there's a conflict, he stops. While he's willing to argue it, I don't know that he's had the time to thoroughly go through it because he had to stop. Okay. Today's the 9th, right?
Yes.
Okay, to try to salvage this and not jeopardize, most importantly, the people's right as well as your rights, Mr. Kyle. I'm gonna do it this way. Timing won't be ideal, but I'm gonna adjourn the hearing on the motion for forfeiture to the 14th in the afternoon. All right. Folks, the people here should, I think, be here. I'm gonna go in the afternoon because you should be here on prelims in any event. So I'm trying to pick that date that causes. I'll be here anyway, so, and you ain't going anywhere, so you'll be here, okay? So that's what I'm gonna do. You understand that, sir? All right, you have any questions about it for me? Okay, all right. That's what I'm gonna do. So I'm gonna adjourn the motion. Your exam, which is really the most important part of this because it's already been adjourned, I'm keeping that on the 21st. Okay, I'm just taking this motion we were supposed to hear today, giving a few more days, let them get caught up, and then I'll hear it on the 14th. Fair enough? Yes, at 1 o'clock. All right.
Is it okay to be talking this is basically his exam one?
Today? Well, they've got to get him back down. So, I mean, because I'm holding the jail up. What's wrong?
Right here or is it?
Around to the R4 door. Okay.
Yes. Thank you.
All right.
But I have this exam one.
Well, so you're his exam lawyer on one of the cases. He has 2 cases set on the 21st. You are the exam lawyer for the witness intimidation bribery case. This case, the public defender is the attorney.
All right.
Okay.
Good luck, fella. All right, hang on. We aren't done yet. I have the rest. I feel sorry for that guy. Like, don't worry, it's all gonna go smooth. Nobody knows who's representing you or what's up, but don't you worry about it. It's all fine. It's all fine. It'll be great. I like how the judge joked and was like, well, you're not getting out anyway, so you'll be right here with me. Okay, so we have the second part of the guy that really, really ticked him off is right here. I've not heard this. So I don't know how it goes. I just know it's right here.
Okay, it's Bill State of Michigan versus James Whip.
Your Honor, for the record, my name is Jeffrey Bennett, very with now again, Mr. Wood, standing to the right, sir, please state your name. James Dennis Whitman.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people.
Anything additional from the defense?
Nothing, yes, Your Honor, one thing additional is that, if the court finds that money bail is necessary, believe that based on this case, an appropriate bail would be something like a 10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be drunk. But the reason I think primarily that the 150,000 insurance bond successful is he has no history of any violence whatsoever. In fact,
Well, can I just stop you there? Because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment. And my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe, because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well, he
one.
wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions. And that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may be intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving with this habit, then, an added condition of he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He went to try to drive her home. She refused. She drove her cell phone. I think I even seen the alcohol test. I don't know whether that's or not. He followed her home to make sure she got there okay. The parties, he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break. I think in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to find, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements were entirely accurate. And wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so her children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and a head. I would clear up, since you gave me the chance. There were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 X-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent. This has never happened. So regardless of whether or not there's a conviction for purposes of bond.
I'm sorry. This guy's driving me up the freaking wall. Did he say anything about, I was trying to tell her to calm down. Did he say anything about that in what we just listened to? And then this thing about him, well, he's just a calm guy. He's got a friend that's been friends with him for 20 years. He's never seen him violent. That's because they're good at hiding it. Some of them aren't. But some of them are really good at hiding it. They don't show any violence around anybody else. We've heard all this before. So I don't like this attorney at all. I don't believe him at all. I get it. He's doing his job, but I just don't believe what he's saying. He just gives me, ugh. That's what he gives me. Nothing good. Gives me the willies.
He does not pose.
Well, if I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now is you're relating to me that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level, because he's not this law-abiding person that you say he is, because he's obviously driving mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparoso, is there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving. Yes, it's violating his restriction. That doesn't warrant $180,000. I do think that some cash bond is appropriate. This one. I think it should be something that helps. Especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What are you gonna say?
I was just gonna say, I think it's all my testimony.
I'm sure it certainly will, but I don't have that at this. Normally when you're in a bond hearing, I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion, how she know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant remanded.
Thank you, Your Honor.
Go one. Court stands in recess. Thank you.
Did he say when the next hearing was? Because I was trying to listen, but I kind of spaced out because that lawyer wears Judge Simpson out. I mean, good grief. He didn't even want to ask, is there anything else? Because he's not, he's going to talk. There you guys have it. Judge Simpson's not so good day. Not so great day. That's it. That's all I have. I feel bad for him. I hope today went better for him. I'll try to listen to see if I can. Uh, I didn't hear him. I didn't hear him say when they were coming back. I would assume the 21st. Could be the 16th. I don't know. That's where he was kind of setting everybody else. He did get his bond reduced, but I assume cash of surety means he has to pay it all, right? Is that correct? Is that what it is? Anyone? Could you imagine? All I was sitting here thinking is Judge Simpson has that okay, he does have to pay the whole 35,000. No wonder he was looking so pathetic. Because he was looking quite pathetic. Oh my gosh. Thank you, Gabby. Stormy, you have a 1 by your name now, which means you've been a member for 1 month. Could you imagine that lawyer in front of Fleischer? Holy smokes. That hearing would have been over in 10 minutes. In 10 minutes, not here, and I have to walk away from you because I'm about to lose my temper. I'll hear you again, and then I'll hear you again, and every time I'm going to lose my temper, and sorry for everybody that comes after. Yeah, I'd just be like, I'm good. I'll stay. All right, guys. Uh, that's it for today. Sorry to be short. I mean, I got a lot of short people in the chat, so I'm just trying to be like y'all. Oh, Stormy, I thought of one more thing that went bad last week. Daryl Brooks went back to court and then ended up taking a plea deal. And so that went off the rails. And then Haley Brown, the DUI person down in Tennessee, she didn't get her sentencing either. So hey, Sarah, how are you? Yeah. Oh, my stomach's growling. I've been like muting this whole time. So yeah, that your list is long of reasons you cannot go on a cruise again. I guess until September. Oh, yeah, because you know why Haley was your fault is because ooh, my camera just like because you're from Tennessee and Haley's in Tennessee. So it automatically connected to you. So we made that. We drew the lines. We did a board with yarn and stuff. Not really. I will be back Wednesday at 10:30. I thought you wanted you want to move to Tennessee? You have something to do with Tennessee. There's something there. Okay. Well, okay. We're still connecting you. we're still blaming you. But now that week is over and you have returned to us. So we look forward to this week going smoothly. We'll see. I think that's all I got for you guys. I don't have any updates on anything. Nothing. But I will return Wednesday at 10:30 a.m. Eastern time. We'll see if anything pops up good. Everything's been just 2 things. Oh, I forgot to tell you. I think did I tell you that Lori Daybell went to Burger King the day that uh, her ex-husband was allegedly unalived in self-defense by her brother. I was going to play the video, but you can't really see it. But I laughed. Like, of course she did, because we all go to Burger King after we commit crimes. That's where we go. Or sometimes before, sometimes during. Just depends on what your case is. So, whoa. Oh my goodness. Ixnay. Ixnayed. Alrighty. We'll see. Wednesday is a brand new day. I do have a phone call that I have to take Wednesday morning, but it is supposed to be over by the time that stream is starting. It is scheduled for 9:15. So if I'm a little bit late, it's because I'm on the phone and I have to take the call. I wish I could tell you it was something exciting, but it's not. So if I'm a little bit late, that is why. But otherwise, I should be on time. So you guys enjoy the rest of your day. Stay safe, no matter what you're doing. Stay dry, Carmen. I don't know what the rest of your guys' weather is like. And I'll see you guys. Yes, be kind to others. I don't know what happened either, Chrissy, but that was a funny, uh, funny message. And Sarah, it took me a minute. I really thought you were trying to type unalived. I was like, man, that's worse than Gabby's talk to text messages. All right. Thank you guys, everyone, for being here. Always a great time. And we'll do it again. So have a great day. I'll see you. Bye.